Counsel?
Your Honor, may I have 3 minutes of rebuttal?
You may.
Thank you, Your Honor. May it please the Court, Jeffrey Kuiper for the people. The class of motor proceedings errors should not be expanded in this case. This Court, in its Orama cases, has developed a very clear and simple rule about what constitutes a motor proceedings error. In every case where defense counsel had notice of the exact contents of the jury notes, this Court found there was no motive proceedings error, and in every case where counsel lacked notice of the exact contents of the notes, this Court found.
What about the judge's responsibility under 31030?
Mm-hmm. Yes, and the judge does have a responsibility under 31030 to respond to notes. I think.
So let me ask you this: What if a judge does advise counsel and read the note, and then counsel and the judge decide not to respond to the note? Could they do that under the CPL?
I think that would be error, but I don't think it would be a motive proceedings error. And I think that's really.
Why is it not a motive proceedings error?
Because there the defense is making a strategic choice. They have an opportunity for input. That was what Orama was concerned about. And in Orama.
Okay, how can that supersede, though, the mandatory language of the CPL, though, right? CPL says the judge must respond.
Right.
So how could the judge and counsel decide together that they're just not going to respond?
Well, again, I mean, that would be error, but there are lots of things that are required under the CPL that are not motive proceedings errors if the error occurs. So, you know, in Orama, the motive proceedings was based specifically on the fact.
So I'm sorry. So it's not a motive proceedings error because it's some other kind of error. So what other kind of error is it? Just a generic error, failure to comply with the statutory mandate?
Correct. Yeah, and I mean that, you know, there are plenty of statutory requirements that don't involve motive proceedings errors, and I think, you know, that rule from Orama is consistent also with this Court's other more recent motive proceedings cases. I would note People versus Consacao from November of last year was a case in which this Court found that the Boykin rights did not involve a motive proceedings error if the defense had an opportunity to object there. So I think the same kind of reasoning is working.
So it's the failure to give notice? That's what makes it a motive proceeding error? The failure to give notice?
Right, because the failure to give notice prevents counsel from participating in a meaningful way, and that's what Orama is really concerned with.
But isn't the statute about both the notice to counsel and the judge's duty and obligation to respond?
Correct. But that wasn't.
That's what I'm saying. Why isn't the second part of it? Why is only the first part of the statute a motive proceedings error, but not the second part of the statute?
Because only the first part prevents counsel from having meaningful input.
But isn't the second part about ensuring that the jury's request is responded to? Aren't we at least as concerned about responding to the jury as we are that counsel may engage in some kind of discussion with the judge as to what would be an appropriate response? Isn't that all geared towards a response?
Well, but the motive proceedings aspect of Orama was geared towards meaningful participation, and so here defense counsel is meaningfully participating in the process and is making a strategic decision to say, you know, I think whatever verdict they've come up with, I think I'm more likely to get an acquittal now than if you tell them to go back and reconsider.
So meaningful participation could mean that defense and the judge decide that there will be no response to the note. So
right,
compliance with half of the statute, you say, is sufficient.
Again, I'm saying it's error, but it's not a motive proceedings error.
Counsel, does the failure by the court to respond to those notes in fact taint the whole process, the whole procedures?
I don't think it does. And I do think it matters here. I mean, I think the question of error here is not as straightforward as it would be in a case where there's simply a decision to not respond to a note. Because I think that here the jury, by sending out a note saying we've reached a verdict, it's somewhat ambiguous, but is arguably indicating that they do not need those notes further. So certainly in that circumstance, defense counsel could request clarification. It's like, I think, like any other ambiguous note. The defense could request clarification, and in that circumstance, I think the court would be required, as occurred in the Laredo case, would be required then to at least make an inquiry about that ambiguous note. I'm not sure, in saying that you've reached a verdict, do you mean that you don't need those previous notes, or do you need to hear answers?
Did the people have any obligation to raise that?
No, I don't think it's the obligation of the people to raise it. It's a strategic decision for defense counsel, and really, the defense is I mean, this is the final moment this is the most important moment of the trial, and the defense is making a strategic decision about.
No, please.
No, so if the people wanted to make sure to clarify this ambiguity, then they would ask the court. But if the defense attorney wanted to know the answer to that, then it's incumbent upon the defense counsel to raise the issue. Is that what you're saying?
Right. And if it was a mode of proceedings error, we'd create the situation where the people could ask for clarification and the defense could say no, and if the judge does what the defense wants, it would be an automatic new trial, which I think would really kind of skew the intentions of ORAMA, where you'd have the defense attorney, having meaningful input and yet getting a...
So the defense counsel says that the judge, yes, I want to know, or I think you should ask whether or not they want the note responded to, even though they've indicated they have a verdict, and the judge does so, and they say, well, yes, we'd like a response. Could the counsel and judge at that point say, well, we're not going to respond?
Again, I think that would be error, but not a mode of proceedings error. Yeah, because at that point you have the defense participating meaningfully.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon. Thank you. Nick Borton of Sullivan and Cromwell for the respondent, Terrance Mack. Mr. Kuiper just talked about the court not expanding the mode of proceedings doctrine. The way I see it, the question this court is grappling with is whether it should be reduced, whether the two core requirements of the ORAMA doctrine, which this court has recognized for more than a quarter century, should in fact be reduced to one.
Counsel, isn't the problem here, though, okay, we have this fact scenario, and the jury's asking for all these different things. I'm the defense counsel. Then they come out and they say they have a verdict. I don't have to object here on the note issue, so I take the verdict, because they've been asking all these kind of questions. They don't understand reasonable doubt. Good shot, I'm going to get an acquittal. Worst case scenario, if we do what you want, I'm going to get a do-over. Why wouldn't you do that in every case?
Because that's not what ORAMA is about.
But forget
ORAMA's not
ORAMA.
concerned
Why wouldn't you
with
do that?
Number one, I'm not sure that missing an opportunity to advocate for your client and to try to influence the jury in a way for a favorable verdict is a real strategy that a defense attorney in that position would pursue, in the hopes of some get-out-of-free-jail card.
How is it that would be advocating for a favorable result for your client? Because if you're talking about beyond a reasonable doubt, there are two parts to that, right? I mean...
But we know here that the jurors' questions telegraphed three things: that they were concerned about what reasonable doubt meant, that they were concerned about what to do about a single witness. Those are both, favorable questions from a defense perspective. But also, they had misapprehended the evidence. They had thought that there was testimony of the defendant leaving the scene, when in fact there was none. There's no way that failing to answer that question could be anything except prejudicial to the defendant.
But doesn't that go back to Judge Garcia's point? I mean, why wouldn't you sit silently and say, this is golden, I'm either going to win or I'm going to win?
Because, whatever defense counsel's motivation is, I think that's the point. 31030 and ORAMA, they don't put the obligation to answer jury questions on defense counsel or the people. That's why it sits with the court.
Am I being unclear in my question? In other words, if the judge is going to not respond to those, I know because of what the Court of Appeals has said, that's error, it's motor proceedings, I'm going to get a do-over unless they come back and acquit, in which case there is no do-over. So I win or I win.
If that's defense strategy, then that I think that emphasizes the point that the burden shouldn't be on the defendant, because what the statute is about, what ORAMA is about is not about tactical decisions that one side or the other might want to make. It's about the fundamental mode in which criminal proceedings in this state are
But
conducted.
isn't it the structure? In other words, we want to make sure that the notes get responded to. Now, one of the notes was we want a smoke break. Now, I would think we could all agree that that was the only note, and then the next one, while we're talking about whether or not we're going to give them a smoke break, is we've reached a verdict, that we don't call them back in and say, would you like a smoke break before going back to deliberate. We would think that would be silly.
Correct.
So the mode of proceedings, the structure's there. All the architecture of what is required under the statute is there. The notes came in, the judge read them, talked to the lawyers about them, and the new one came, and no one said, well, wait a minute, we got to cover these, because I think, as was suggested earlier, defense is making a tactical decision. Prosecutor probably is too, and we get a verdict.
And again, the way the law in New York is designed is not to put that judgment with either party.
So
It's up to the
the
court.
smoke break, it would be an error if he did not give him a smoke break.
No, I think the court's
Well-
case law is clear. It needs to be a substantive jury question is what triggers 31030.
Doesn't say that.
What
It
makes,
says that. It says a question about the law or about the facts of the case.
Okay.
The statute itself references a question of substance, not, when are
So
our
let's
dinner
say
menus
we,
coming?
say it's a mode of proceedings error if the court doesn't give a meaningful response. Would we then be at the point where we would continually litigate what is or is not a meaningful response?
No, because this is where the Nealon case this court decided in
I'm familiar
October
with
is
it.
so instructive here. And it really, it takes, all of the Arama jurisprudence and it distills it to a very simple rule, the application of which I submit is simple here. And that rule is this, that preservation is required where the court discharges its core duties, but does so imperfectly, and the defense counsel had an opportunity to have input into
But
that
does
discharge
that mean
of
in
the
this
duty.
particular case, let's assume everything happened as the way it happened, and the judge says, so I'm going to bring them out and I'm going to answer these questions. Defense says, Judge, don't. They've said they've reached a verdict. We want the verdict. Would the judge be wrong then to say, I don't care, Mr. Defendant, you may think this is your trial, it's mine, and I'm going to give them this information even though they've now reached a verdict?
Absolutely.
Really?
Well, of course, because that's what the judge is required by law to do. It doesn't mean the judge has to answer the questions necessarily, but the judge has to assure himself or herself that the jury reached a verdict based on a proper
What do
understanding
you
of the
mean
law.
they don't have to answer the questions?
No, it may very well be that the jury satisfied its question itself, but the judge can't assume that. It can't be implied.
He should call them out and say, I've got 3 notes from you. I also got this verdict one. Do you want me to answer the 3 before announcing your verdict or not? Is it-
Correct. Simple. It could take less than a minute.
Counsel, I'm not clear. You referenced twice, I think, the counsel's opportunity to be heard here. Are you suggesting that counsel did not have a full and maximum opportunity to be heard under these
No,
circumstances?
what I'm saying is under the law of Nealon, the opportunity is important if the court discharges its duty in some way but makes a mistake in how it does it. But I think what the case law is clear on is if the court utterly fails to discharge the duty on the notice side by failing to even alert defense attorney to the note, or on the response side by failing to respond to the jury questions, then that is a mode of proceedings error.
how does
And
that
whether
square
counsel,
with Consecao?
I'm sorry?
How does that square with the Conseco or Consecao case?
Well, I don't think this court has ever held in any case that a complete failure to respond to a jury question requires preservation by defense counsel.
But
The court has
it's a
never ruled that way.
unique case here, right? Because, putting aside the hypothetical I put before, you have the verdict, so it could be, as some appellate departments have held, that the judge believes that the jury has now withdrawn its prior outstanding requests articulated in those notes, right? So it's not necessarily a choice not to respond. It is one where the judge views the circumstances as there is now no request on the table to which I must respond. Why can't we
But
view the
that-
case
that-
that way
that-
for this narrow class of
That
cases?
can't be, because if there is some implied withdrawal, then that would swallow up the Arama rule itself. Because that would mean anytime a jury reaches a verdict, it cures whatever failure there's been up to that point to answer a question.
You know, the more interesting question I thought was Judge DiFiore made reference to the integrity of the process as a whole. And all of us are concerned about that simultaneously. And I wrote Nealon, and in Nealon, I think what the court was saying there is the integrity of the process is compromised, like you said, if we don't know, if we simply don't know, if there's no notice. Meaningful response, though, is not the same. Response isn't really the same situation. Then it gets into responding, creates a situation where an attorney, an effective advocate, is going to want to get his client acquitted. That's his job. His job is not the integrity of the process as a whole. That shouldn't be his burden.
Exactly.
The judge is to make, we're assuming here that the judge made an error. The question is whether or not the error transcends to that relatively rare situation where it was impossible for them to make, by them I mean the attorney, to make an intelligent choice. And that's, I think, what I'm struggling with here. And that's why I don't see notice as the same as response. But I think you are right, though, and I think we all agree that we're really reaching here for what ensures the integrity of the process. But I don't see how you convince us on response just yet.
Well, I would submit, Judge Fahey, that the response is that much more important even than the notice.
But your proposal would eliminate all strategic choices for defense counsel.
Correct. Because Orama is not about strategy, it's not about tactics. You know, to impart a requirement of preservation now, it doesn't do away with tactics or gamesmanship.
How do you
it just
figure
changes
this?
it.
In this situation where they wanted the testimony with respect to the person leaving and one person, now they've reached a verdict. The 12 of them have decided unanimously to go one way or the other. You're calling them back and you're saying, I'm going to give you that instruction on one witness, and I'm going to give you the instruction, and I'm going to tell you that no one saw him leave. Does that put the judge in a funny situation where it sounds like he's dissatisfied with the verdict that he knows is coming, and he wants them to review two things that they apparently have decided either they don't want to do, or they've reached whatever wrong conclusion that they may have reached instead?
But all the court has to do is inquire as to whether they've satisfied themselves as to their questions. It is
Well,
a
if we
mistake.
rule in your favor, again, it's a unique sort of circumstances. You have a verdict, you have these outstanding notes. If we rule in your favor on the question of gamesmanship, what's the gamesmanship? Doesn't the judge know that when a verdict comes out, I should either ask, I should not assume, and that way we avoid this problem of there will be no response? Because your argument is about the total lack of a response.
That's exactly right. The only way to do away with gamesmanship is to tell courts, to insist that courts do what the law requires them to do. Then there can't be any gamesmanship. A preservation requirement was just going to generate gamesmanship of a different sort.
What's gamesmanship, in your view, in this case?
Gamesmanship is allowing a tactical decision by defense counsel that can later be second-guessed on appeal as having...
I see. Okay.
But
Thank you, counsel.
Isn't
Go ahead, Judge Garcia.
gamesmanship here, like any time when we want preservation or we look to preservation, that a judge makes an error, and you know it, but you hold it, because you know you don't have to object. So later on in an appellate setting, you can say motive proceedings error. I get it reversed. That's gamesmanship to me, and that drives our preservation requirements, which is why if you have no notice of a note, under your example earlier, then we could say, look, that's a motive proceeding error. You didn't have an opportunity to do that. But gamesmanship to me would seem to be in the preservation context. You know the judge has committed an error. You have an opportunity then to object and to correct the record here or to make an appropriate process going forward, but you don't, because you know you don't have to, and later on a court will take care of it for you.
But I suggest you're just creating a different types of gamesmanship here, because then there will be second-guessing the trial counsel's failure to object, to preserve an error, which can lead to ineffective assistance of counsel and other
But
claims.
that's an argument for any time not having a preservation requirement.
But preservation requirements are critically important when the judge may inadvertently make a mistake and there's a duty on counsel to speak up. This can't be one of those cases. The question is put to the judge. The judge knows it's his responsibility or her responsibility to respond to that question. He or she doesn't need counsel
But
telling them
where
that.
does the jury fit in that equation in your answer? Isn't the point of the statute to respond to a jury's request?
To make sure that, exactly, to make sure juries are rendering a verdict based on a proper understanding of the law. That's what 31030 is all about. That's what ORAMA is all about.
Then anytime there's a statutory requirement for a judge, there's no need for preservation, because he knows the law.
This court has held for 25 years that in this context, which this court has described as the most, in some ways, the most critical moment in any trial, this court has said, is when a jury comes back with a question, because the answer to that question may very well determine the outcome of the jury's deliberations.
But if a judge gives an instruction or a response on a note and there's no objection to it, but later on court might think that's not the right instruction, does the defense counsel have an obligation to object to that?
If the judge gives a response, at
Right.
that point, the
But
judge
why
has...
isn't that the fundamental part of the trial where he's telling the jury an answer to a question?
Because the court has at least, attempted to satisfy the court's obligations, the core obligations. And Nealon says, in that case, preservation is required. But if the court utterly fails, it isn't. That's what this court has always held. I know I'm long over time, but just let me finish with one final thought. This court cannot reverse the Fourth Circuit here without essentially overruling ORAMA. These facts, I suggest, are the worst facts imaginable to overrule ORAMA. This was a razor-thin case based on a single witness, and the jury understood how weak the evidence was. Because we know that because they were deadlocked at 5:42 p.m. They were sent back to deliberate, and given the impression that they would deliberate all night if necessary before they reached the verdict. They waited 94 minutes for answers to 3 of the most important questions that a jury could have based on the facts here. They never got those answers. There is a strong concern here that the verdict in this case was not based on the evidence, but as a result of coercion, because the jurors...
Coercion?
Coercion from the circumstances, that it was now 8 o'clock on a Friday night.
I realize you're right. Now you're saying, that the judge should have sent them home and that told them they may be cloistered. In my mind, I was thinking, maybe the mistake here was the judge let them deliberate through dinner. But I don't think any of that's coercion. I think that's just the normal processes of the court.
But it was a jury who had reason to believe that they were never getting an answer to their questions.
Okay.
And doubts were overcome by the stress of the moment and not by the evidence. The court should affirm the Fourth Department and overturn the verdict.
Thank you, counsel. Counsel?
As to gamesmanship, Nealon discussed gamesmanship, and if it were sufficient to say the court knows the law, therefore gamesmanship isn't an issue, Nealon would have come out differently. So I think that's really not an answer to that problem.
But in this kind of narrow case, where there are lower courts that have permitted, that recognize this implied withdrawal of a note, if we resolve that, if we were to agree with the defendant on that point, that you can't rely on that, wouldn't that at least put that question to bed so that judges moving forward would not repeat that error, which is a failure to completely respond?
Right.
It's different from other errors.
Right, and certainly this court could clarify this. I don't think you have to reach that question because I think the mode of proceedings issue is dispositive. But you could certainly reach that issue. It would clarify things. Judges sometimes make mistakes, and that's true of all kinds of different errors. And the fact that a judge may make a mistake doesn't mean that it's a mode of proceedings error automatically. As a general rule, the defense has to object when the judge makes a mistake.
Could the people have objected?
Yes, the people could have objected, but both sides are making a strategic choice. As counsel said, this was a razor-thin case. This was a close case. The jury was deadlocked for a while. Both sides are making a strategic decision about, what do I think is going to get the outcome I want here. The defense is thinking, I don't want you to give them more information. I think they've settled on an acquittal. And maybe And maybe if they haven't, I've got in my back pocket an automatic
I
reversal.
guess what I'm asking, if the judge is choosing not, forget the error, as in, I didn't realize it, I didn't know. Choosing that kind of an error, conscious choice. I think the jury has withdrawn the requests. Let's say we disagreed with that. Why isn't that error fall right within 31030, that you have failed to respond to the jury request?
Right.
And in that circumstance,
But
it doesn't matter if the defense counsel raised a question, because the duty is on the court, and you made a choice not to respond.
Well, but again, I mean, I don't think the fact that the court makes an error makes it a mode of proceedings error. And I think, there was a case.
I understand that point. I guess I'm not understanding why you elevate the notice to the mode of proceedings error. Perhaps you're relying on Nealon. I want to be clear why that, because that's the first part of the statute. Why are you unwilling to elevate the second part of the statute?
Because the first part is what prevents counsel from participating meaningfully, and that really is the core of ORAMA, whereas the second part does not do that. And so once counsel has the opportunity, is making...
No, but the point of that is to get a response to the jury, right? I mean, isn't that what the whole point of that is, to get the response to the jury?
But I don't think that's the point of the mode of proceedings error. And so the People v. King from last month was a case in which there was not a mode of proceedings error found, in part because defense counsel was making a strategic decision not to object, or possibly making a strategic decision not to object. So I mean, I think that is critical to the mode of proceedings error analysis, as opposed to the analysis of whether the statute's being complied with.
Thank you.
Thank you.